So, can you create your estate plan by yourself using DIY, AI, and other tools and legislation that's available to you? That's what we're going to talk about. Greetings, everybody. Hey, Larry. Hey, Chelsea. Good to see everybody. This is a different live stream. Virtually all of my live streams are all about this is how you can leave things for your spouse. This is how you can save taxes. This is how you can leave things to your children. This is who you should appoint to do this or that. Here's what a will is. Here's what a trust is. Here's the different ways you can use them. Here's if your family circumstances are this, you may want to consider that, and so forth. But this one's a little bit different. Probably won't keep you quite as long as I normally do. But I want to talk about the whole AI, DIY, and how it relates to estate planning. I'm very excited about it. Love the fact that there's new technology. Anything that can, if used properly and if it's available, anything that can help more people kind of leave that impactful inheritance, that impactful legacy to their survivors, anything that can make that easier for people, kind of lower the bar. I'm all for it. So I'm at a point in my career where I just want to see more people get it right. I was the recipient of an inheritance when I was about 8 years old. It enabled me to really do some things with my life, go to college, go to law school, and kind of jump-started some things. So love to see it, that kind of thing happen around here. So and AI and is all about that. So I want to break this down really. Generally speaking, I want to talk about some of this is going to be AI related. Some of it's not. Some of it's going to be kind of DIY, do it yourself. Some of it's legislation. So I'm lumping it all together. Maybe this is more of should estate planning attorneys be concerned that they may lose their job because AI, DIY, legislation all packaged together is some kind of estate planning attorney unemployment act. So it's not, as we'll discuss. So feel free to mention things in the chat. Got a lot of stuff to go. I want to break this down into some of the legislation that just encourages the public to do it themselves, do estate planning themselves. I want to talk about some of the shortfalls of legislatively permitted estate planning, as I call it. I want to talk about DIY providers. I want to talk about AI in estate planning. I want to talk about kind of what it's going to look like in the future. What will the attorney role be? What will technology's role be? But like I said, I'm excited. First, let me talk. It has nothing to do with AI. That's DIY, do-it-yourself will and trust forms. Nothing to do with that. Let's talk about where kind of legislation is enabling more people to do it yourself, DIY. Is that a good thing? So when we talk about legislation, federal or state legislation encouraging people to do estate planning themselves, let me go over what I'm talking about. And some of these things you're going to be very familiar with. So here's the deal. And look, I'm not that people should always do it themselves, but I have many conversations all day long, every day with people, and they tell me what they've done. They tell me what they're doing. They tell me what their parents did. So I had a pretty good feel for I know what's going on out there. But yeah, legislation clearly is encouraging more people to do estate planning, or at least a big part of estate planning themselves. Whether it's right, wrong, or indifferent, we'll talk about that. But nonetheless, people are trying to figure this stuff out themselves and realizing that they don't necessarily, or at least they feel like they don't need to go to an estate planning attorney with every estate issue that they have. Let me give you some examples. Biggest financial asset that people have typically is their IRA. And for decades, people have been able to designate beneficiaries on their IRA. Heck, in many circumstances, many financial institutions, you can go online and change your beneficiaries on your IRA. So you may have a $3 million IRA and then a checking account with $10,000 and a car worth $10,000. To leave your checking account and your savings and your vehicle to someone, you've got to go see a lawyer, got to draft legal documents. In many cases, got to get it notarized, witnessed. You wind up with a bunch of bulky paper. But if 98% of your estate's value is in your IRA and you can simply go online, name your beneficiaries, and electronically sign that change of beneficiary designation, that enables a lot of people to do the bulk of their estate planning outside of estate planning lawyer involvement. And it's not restricted just to your IRAs. Now, all your bank accounts, your credit union accounts, many banks and credit unions permit their account owners to fill out POD designation forms. And so the whole sole purpose of that is, who does the bank give this money to when the account owner dies? Many, brokerage firms and stock accounts, you're permitted to have TOD designations. It's the same thing. Those non-retirement, non-IRA accounts where you can create a TOD designation and designate who you want things to go to. Is that the way everybody should do it? We're going to talk about that in a minute. I'm just telling you that this exists. I think it's 27, 28 states now permit people to title their home with a transfer on death deed. So you title your homes. I want my home transferred to these people when I die. It's still your home. You do whatever you want to with it. You can sell it. You can mortgage it. But if you still own that home when you die, it's going to be transferred to the beneficiary or beneficiaries that you designate in your transfer on death deed. So I mentioned 27, 28, 29 states permit that. That's another kind of do-it-yourself vehicle. And then some states permit, if you own a small business, you own an LLC, some states permit you to designate who your LLC is to be transferred when you pass away. That's some type of LLC transfer on death designation. Some states permit it. Some states permit you to title your vehicle in a way. So when we look at the main assets that people own, their retirement accounts, that's a big one. Their home, 29 states, TOD designation. Other financial accounts, POD for bank accounts and credit unions, TOD for brokerage accounts. Now LLCs can be done TOD, not in all states, but in some. And vehicles in some states can be registered so they're transferred on death to a particular person. You're starting to see how there's this phase out of having to get a lawyer involved to effect the transfer of every asset that you own when you pass away. Now, there are some, not the TOD, POD beneficiary designation is not the perfect answer in many circumstances. Let's talk about some of those maybe shortfalls of what I call this legislatively permitted estate planning. It often creates some unintended consequences. So, for example, I've reviewed many TOD designation forms. I've reviewed many other beneficiary designation forms, POD forms, and they usually say, okay, who are your primary beneficiaries? And they give you a few lines. Let's say they give you 5 lines, but maybe you'd want your $200,000 bank account to go to your 3 children, and that's who you list on your POD designation form. Well, you have to read the fine print in those POD designation forms. Just as an example, doesn't happen every time, doesn't happen most of the time, but let's say one of those POD beneficiaries dies before you. Well, if I had a nickel for every POD, TOD beneficiary designation form that in the fine print says if one of the primary beneficiaries named dies, then the account shall be payable to the surviving primary beneficiaries, which often is not what many parents and grandparents want. They would want, if a child predeceased them, they would want the child's share to go to the child's children. And that's often what's reflected in the estate planning legal documents. However, if the TOD designation controls and you can't cover a lot of these contingencies, it could cause some unintended consequences. Also, people sometimes too much oversimplify their estate planning by using the TOD beneficiary designation, because all you do there is you list some names. But naming beneficiaries in their own name prevents that continued management of the assets after you pass away, which is sometimes necessary. So you never want to name a minor to inherit or to be a beneficiary in their own name. That's a disaster, because then there's court proceedings. Guardians have to be appointed by judges. Judges oversee the assets until the minor reaches the age of majority and when it's dumped in their lap. So you always want to make sure you leave things in a trust for a minor. If you leave things through a TOD or beneficiary designation to a young adult, somebody who's 19 and 20, maybe it's not appropriate for them to get that lump sum inheritance. So again, using a trust is a good vehicle for that. A lot of our clients, I was having a conversation online with a financial advisor today who was talking about the different types of ways people can leave their estate to their children. And he was like, Paul, what do you see most people do, or what resonates the most with people? Because I had explained there was maybe 7 or 8 ways that people can leave their estate to their kids. And so I, in our online communication, I was like, well, what seems to be resonating today or these days with people wanting to try to preserve what they have for themselves, for their family, is what seems to resonate is this leaving assets in a trust, not because someone is not responsible, not because the child is not responsible, but leave assets in a trust for them so that those trust assets would not be commingled with other assets that your child may have with a spouse. That way, if your child gets divorced, your child keeps their trust, and then your child and their spouse split the other assets that they've acquired during the marriage. So none of that really kind of legislatively permitted DIY stuff that enables you to designate beneficiaries on life insurance policies, IRAs, Roth IRAs, 401ks, TOD beneficiaries, POD beneficiaries, LLC TODs, home title transfer on death deed. You just don't see people naming a trust as a beneficiary because, again, they're trying to kind of keep it simple and do it themselves. And but that extra expertise that's not available when you're just putting names down on the beneficiary designation form doesn't often do what it needs to do from protecting it from your children, protecting it from their spouses, from their creditors, from their mismanagement. In addition, one of the worst things you can do is name a special needs child in their own name as a beneficiary on one of those TOD, POD forms. Again, the idea there is leave those assets to a particular and customized special needs trust. That way, if in the event that that special needs child is receiving certain government benefits, leaving things to a special needs trust for that child that is designed to supplement the benefits that the child is getting from the government rather than replace those benefits that the child is getting from the government. So important if you have children with disabilities, leaving those assets in trust. So all of these things here, do many people use TOD beneficiaries? Oh God, yes, they do. POD beneficiary designations, they're doing it themselves. But estate planning is complex, and sometimes that human or attorney involvement is crucial for really understanding the family dynamics, addressing the sensitive issues, and ensuring that the estate plan aligns with the client's values and their goals. Okay, so that was kind of my first thing I wanted to address, was the kind of what's the deal with this legislatively permitted estate planning, where now more than ever, you're able to just kind of slap beneficiary designations on just about anything. Is that going to work for you? It might, but there are some pitfalls you need to be aware of. So that's number one. Number two, I'd say, well, what about the kind of DIY providers? There's, I guess, dozens of companies out there that offer this kind of fill in the blank document preparation service. And I'll tell you, they have to draw, there's a real fine line that's drawn. Let me tell you kind of my quick story. I was approached years ago by a company that was starting this do-it-yourself document provider software company. And I was the legal aspect of it. And now this company, look, it no longer exists. It was acquired by a financial services provider. The company no longer exists. But we did set up some pretty cool, kind of easy to use decision tree, kind of do it yourself stuff with, and at every point in the decision tree, there was explanations, text explanations, and video support. Videos were made by me at every step in the decision tree, and I felt like it was a high quality product. But the problem was, and the problem with the kind of fill in the blank, do it yourself document provider services, a couple of problems with it is people tend not to follow the instructions that are provided, and there's so many nuances with estate planning, and so they would make errors that are just kind of unavoidable because you're using a DIY platform. So as much as we try to avoid it, for example, I'll give you an idea. There was some, obviously we enabled people to create their own wills using the software that we created. And we would put kind of warning, warning, warning. You cannot leave your IRA to someone in your will. I mean, technically you can if you go back to the beneficiary designation form and designate your estate, and then the IRA goes through your estate, and then your will does address who inherits your IRA. But there's a whole bunch of negative income tax consequences when that happens, because the states have to pay the income tax on that IRA a lot faster than a spouse or a non-spouse individual would have to pay income tax when they inherit that IRA. So it was kind of warning, warning, warning all over the software. Don't attempt to leave your IRA to someone through your will. It's all done through your beneficiary designation. Well, lo and behold, there'd be a place in the DIY software where you can list that you wanted certain assets to go to certain people. And sure enough, people would, in the very limited and controlling areas where they were permitted to type in the asset that they wanted to leave to someone in their will, lo and behold, they type, I want my IRA to go to so-and-so. So there's just going to be problems like that. Sometimes people would own maybe 3 different properties inside of an LLC. And it, a lot of people don't understand this, but you may own property A inside of ABC LLC. You may own property B inside of ABC LLC, and you may own property C inside of ABC LLC. So what do you own? Technically you don't own the properties. You own an LLC that happens to own 3 properties. But as much as we warn people, they'd still try to leave particular assets that were inside of their LLC to certain people when they die. So lots of nuances there. Some people would want to name, 7 people as the successor trustee of their revocable living trust, or just do things that we knew they were asking for trouble by doing, but there was just nobody there to guide them through it. And quite frankly, the DIY providers, they have to walk a fine line, because every state has their unauthorized practice of law provisions, which say that non-lawyers can't render legal advice. And so rendering legal advice is if somebody's trying to fill out kind of a do-it-yourself online and they call someone for support, well, really they're calling and asking for legal advice. So to the extent these DIY companies or non-lawyers are day after day providing legal advice to these people, they're risking that unauthorized practice of law violation. So there's a fine line. I guess the first company that started in a big way dealing with this was many, many years ago. It was LegalZoom. They've gone through many hurdles to try to enable that, try to enable them and other companies like them to be able to do what they do without, lots of regulatory difficulty. All right, so we've been through the legislatively permitted DIY, where people, there's in many cases, there's not an asset that you don't own that you couldn't in some way put a beneficiary on it. Does that work? Sometimes it does. Sometimes it doesn't, depending upon what your needs and your circumstances are. So let me get into now a little bit of AI, and I love AI. I use AI not for purposes of telling AI to create wills and trusts for the clients of our national estate planning firm. Maybe that's coming, but we don't use it for that. But on things like this YouTube live stream, if there's a topic and I kind of need some bullet points to talk about, AI is great. So and it'll give me some bullet points, and just it helps me make sure I'm not missing something. I'll have my own list of bullet points, and then I'll ask, Chat GPT or whatever to give me their list of bullet points. And sometimes they're a little bit wonky, but I'd say I'm almost to the point where I use some form of artificial intelligence every day as an estate planning lawyer. In part because I'm putting out a lot of content and I want to double check kind of my own internal content to what AI provides. I don't ever have AI write my content, but it's nice to have it as a backstop, and that's what it is for now. All right, but I will say the estate planning legal services industry is really different. And it's different because we have our ownership rules on who can own a law firm. And so the progress of the estate planning legal services industry is generally slow because our rules of professional responsibility state that non-lawyers are prohibited from owning law firms and from fee sharing by lawyers with non-lawyers. So non-lawyers can't own law firms. Yes, there's a couple of states that are dabbling in it, Utah, Arizona, but generally law firms must be owned by lawyers. So it has created a very, very fragmented industry. You look at the financial services industry, you got the bigger players, the Fidelity, the Schwabs, the Vanguard. I don't know what their market share is, but I'm sure there are providers who own 2, 3, 4, 5% of the market or more. Doesn't exist in the estate planning legal services industry. Bunch of small shops, some big firms who have maybe an estate planning department with a few lawyers, but it's very, very fragmented. There's no one provider out there of estate planning legal services that has 1% of the market. So because law firms cannot be owned by non-lawyers, the progress of the industry is slow. But I think it's probably coming. I don't know when. It might be 2 years, it might be 30 years. But once non-lawyers start owning and operating law firms, then you're going to have some seasoned business professionals with significant resources, those Fortune 500 companies and their CEOs and venture capitalists and hedge funds. They'll start entering the scene. And these are the people who are the experts at maximizing efficiency, gaining that market share, and creating a competitive edge in the business. But it just doesn't exist, and it can't exist legislatively because in just about every state, non-lawyers can't own law firms. Only lawyers can own law firms. So the progress of our industry will be slow. Now, attorneys are always going to be needed, even though we have AI, and it's very unlikely that artificial intelligence, AI, will fully take over estate planning. I do see, and it's already happening, AI can assist in many aspects of estate planning. I'm sure there's going to be a lot of products out there on the generation where AI can generate diagrams and flow charts of how an estate will flow. AI will be able to generate potential estate tax liabilities based on the assets that you own now and how those assets may appreciate or depreciate in value over the years. So a lot of that is done really kind of manually by estate planning attorneys these days. And so AI is going to assist with a lot of that, which is going to be fantastic. But estate planning does often involve some complex personal and family considerations that do require human expertise, some empathy, and some understanding. And that human involvement really, in my view, is crucial for understanding the unique family dynamics, addressing those sensitive issues, and ensuring that the estate plans align with the client's values and goals. So while AI will continue to enhance and optimize estate planning processes, it's improbable that it will completely replace the role of human estate planners. So my feel is there will be a blend of AI driven estate planning solutions and that human/attorney expertise, and that'll just create a blend of of tech powered precision and personalized advice. So AI is coming. Can't wait to use it. Hope people use it the right way. I will tell you my experience. I have asked AI to prepare some wills and to prepare some trusts. And while AI is spot on in many circumstances and in many things that you ask it to do, it's not spot on the will, trust, power of attorney preparation at this point. In fact, many of the estate planning documents that I asked AI, hey, just give me a John Doe type will, and this John Doe would want to leave his estate this way to his wife Jane Doe and this way to his kids. And I was fairly particular about what I wanted AI to do. AI gave it a shot, and it created something that kind of looked like a will, but when you looked close, even AI kind of put out the warnings. Hey, estate planning laws vary from state to state. Make sure you comply with the appropriate state's rules. So I felt like they're still way off the mark in terms of just even the preparation of just the basic kind of wills and trusts and powers of attorney and other estate planning documents that people need. But I'm sure it'll improve over time. And again, it's that combination of the AI driven solutions and that human/attorney expertise. So just wanted to summarize by saying, yes, the whole, can people do estate planning themselves? Kind of. And if they do, are they going to get it right? Maybe. So there are more tools available from the legislatively permitted types, with different states' legislatures authorizing POD, TOD, TODD, transfer on death deed, LLC, transfer on death, vehicle transfer on death. You do see a lot more of the people doing it themselves. You're also seeing dozens of kind of do-it-yourself document preparation systems, but they have to really stay away from that unauthorized practice of law provisions. In some states, it's a felony on their books for someone to engage in the unauthorized practice of law. Other states, it's a misdemeanor. But that's the problem with the kind of do-it-yourself online documents. They have to steer clear of rendering legal advice or violating their state's provisions of the unauthorized practice of law. So they can only go so far. And then AI is still short on creating and customizing estate planning documents, but it's getting better by the day, and I'm sure. But because just like in the financial services industry, some people just want and need that handholding by a financial advisor. I have a financial advisor just because I like that advisor as a second pair of eyes, keeping me on track. I can, throw ideas by them, get feedback before I make those informed decisions. So estate planning legal services is going to be like that for many, many years as well. All right, Ms. Mel, businesses and companies are allowing computers to put human employment and financial independence in traumatic distress that will cause the overwhelming detriment to family survival. Okay, so Ms. Mel is shining a negative light on AI, and I'm sure lots of mistakes will be made with AI. And so we just have to proceed with caution. ChatGPT was not able to play chess, so its complexity is limited. Interesting note there, Susie. I think ChatGPT may have passed a bar exam. So, but even though they can pass a bar exam, that doesn't mean they can have that empathy and that expertise and that precision that's necessary to guide people through all the nuances and complex aspects of estate planning. So it's a tool. We have to be aware of it. I'm excited about it. Always like new tools, as long as they're used properly. And so we'll see where it goes from here. So still, as far as estate planning attorneys, the cream will always, just like in any industry, the cream will rise to the top. Those, outstanding service providers will always be needed. And so it's a combination of you using what the legislature permits, taking advantage of what AI offers, and then having that human experience and expertise put all that together, and you should be in good shape, leaving that impactful inheritance for your family. One final note. I did create a LinkedIn newsletter today. I'd love to see some of you subscribe. I know we've had dozens of people subscribe just in the first few hours. So I'll be putting out some content regularly on LinkedIn. Real easy for you to find my personal LinkedIn page under Paul Rabelais, and then should be able to find my newsletter and subscribe to it. And I'm really excited about sharing some content on a very regular basis on LinkedIn. It makes it real easy for somebody like me to create that newsletter and then get it out there. So feel free to subscribe. By the way, Joanne, within minutes, maybe after we finish the recording, I think this is going to be available in perpetuity on YouTube. So you can find it there. Larry, thanks again. Still putting my schedule together for future live streams. Y'all check my community tab from time to time. We'll see you next time. Take care.